to make some additional comments about the exchange you had regarding your communications with the payday, Marshall Miller?
Yes, thank you. Chairman Jordan didn't ask me this directly, but I just wanted to make sure it was clear on the record. In the series of conversations that I had with Marshall Miller before I accepted the position of special counsel, previous to discussing the idea of working on any of these investigations, he did bring up the idea of me working on another case before that. So that happened, and I ultimately declined to work on that case, and then the other conversations happened after that. So I just wanted to put that on the record.
Okay.
Another case not related to?
Not related, correct.
At that point, were you ready to seek a new opportunity? You know, you had been in The Hague for some time. Were you looking for an opportunity to come back to the United States? I
really loved my work in The Hague, but for family reasons, if the right opportunity happened, I wasn't desperate to come back, but if the right opportunity happened, I was willing to do that. That's one of the reasons I spoke to Mr. Miller.
Okay. At the end of the last round, I asked you whether you had any communications with the Michigan Attorney General, Dana Nessel, and you said you did not.
Yeah, I don't recall any.
And to the best of your knowledge, you don't believe anyone on your staff was having communications with the Michigan Attorney General's office?
Well, what I thought I said was I don't recall that. It may be that we got inquiries from them. That may be possible, and it may be we responded to those inquiries. I don't recall sharing information with them or getting information from them.
But to the extent there's an allegation made that your office was coordinating with state attorney general's offices to have prosecutions go on, and different prosecutions happen in the states, would you say that did not happen and that would be false if somebody made that allegation?
We were not trying to coordinate prosecutions with other offices, no.
Okay, and you were not trying to encourage prosecutions at the state level?
No, I don't recall anything like that.
Okay. And so the same can be said with the Attorney General for the state of Wisconsin, Josh Call. Did you have any communications with him?
I've never spoken to Josh Call.
Okay.
Again, we may have got inquiries from their office, and it could be by phone or by a letter. I can't say that didn't happen.
Okay. And to the best of your knowledge, your staff did not have a regular set of communications with the Wisconsin Attorney General's office?
I don't know about regular. If there were requests or if there were people who reached out to us, we may have spoken to them back. I don't recall with much specificity anything about that. We definitely were not trying to coordinate a case with them.
Okay. And can the same be said for the Attorney General for Nevada, Aaron Ford?
I don't even know that name, Aaron Ford. Again, I just want to be clear. This subject you're asking me about interactions with State Attorney General's office, this was not a focus of mine. As the special counsel, I was focused on our cases, our investigations, and our case and what we were doing in court in our investigations. This is the sort of thing that other people in my office would have dealt with, and so I'm probably not your best witness in terms of the level of interaction or witnesses, but I don't recall sharing evidence with those offices.
But if your office did have meaningful coordination with the state attorney generals, you probably would know about it. Is that fair?
Meaningful coordination, I don't know what that term means, but like I said, I'm trying to be as specific as I can, limited by my memory. I don't recall us sharing information or sharing our files with attorney general's offices. I don't recall them giving us their files, things of that nature. Beyond that, the number of times an office may have reached out to us and how we replied to that, I really don't have a recollection of those sort of subjects. I'm trying to be as clear as I can.
Fair enough. How about with outside Democratic lawyers such as Norm Eisen? Did you have any communications with Norm Eisen?
No.
During the pendency of your investigation? Do you know if anyone on your staff did?
I don't know of anybody having such a communication, no.
Okay. And how about with Mark Elias? He is a election law attorney for Democrats.
No, I've never met him.
Okay. And to the best of your knowledge, your staff wasn't communicating with Mr. Elias?
To the best of my knowledge, yes.
Same question. A gentlelady by the name of Mary McCord.
Mary McCord, I do know. I didn't know her well, but I knew her from when I had brief interactions with her. She was, I think, at the U.S. Attorney's Office in Washington, D.C., while I was the Chief of Public Integrity. I don't recall having any interactions with her during the pendency of the investigations. At the conclusion of the investigations, one of my lawyers went to work at her project at Georgetown, and I did speak to her about that.
Okay, and what is her project at Georgetown?
It's some sort of clinic at Georgetown University. As I sit here right now, I don't know the specifics.
But you didn't have any discussions with her about the facts of the case?
No, my recollection, that may have been the first time her and I had ever actually had a conversation, her and I talking to each other.
Okay.
But we definitely didn't talk about the case while it was being prosecuted and investigated.
Okay. We've discussed, both sides, I think, have, raised the fact that President Trump was, he's being prosecuted by a lot of different tribunals at the same time. I mean, he had the District Attorney of New York, he had a civil case with the Attorney General for the state of New York, he had two federal cases, and, I had asked you about how you managed the calendar and the calendar with President Trump. I mean, there were times when he was required to be in New York 3 or 4 days of the week, and then he had to be in Florida for, I think we discussed at the end of our last round, for a pretrial motion hearing. And it just seems that at every instance when President Trump and his lawyers requested a little bit of a delay because of the cases they're defending, your office was not willing to indulge that request.
It is correct that we were not willing to indulge delays that we thought were inappropriate. I will add, and this is in the litigation, there were numerous instances where judges chided counsel for President Trump for trying to delay things. I'm thinking, as I'm saying it now, I'm thinking specifically of the executive privilege litigation that we had. This is referenced in our final report of him attempting to delay things. And so we agreed to dates that we thought were appropriate. All of that, as far as I'm concerned, was very public and transparent. What the dates were and the arguments to the judges about those dates were clear, and I thought they were fair and reasonable.
Even against the backdrop that he was being tried by the District Attorney of New York, and even against the backdrop that he was involved in a high stakes proceeding with the New York Attorney General?
Yes.
For example, at the time you proposed the DC schedule, you were also aware that Georgia prosecutors had proposed motions hearings, essentially during the same time period. If President Trump's lawyers had requested a delay for that, would you have indulged that? Or did you indulge that if they did ask for it?
I don't recall if they asked for a delay, and to consider whether I would indulge that, I would have to be back in that moment and look at the facts as they existed at that time. I don't recall that as I sit here now.
President Trump complained that he was treated unfairly with respect to access to the classified information that was at the heart of the Florida case, that he wasn't able to review the materials at the heart of the trial because of restrictions imposed by the government that required him to only review the materials, on your turf. Is that something that your office did intentionally?
I think this may be one of those subjects that may be in the final report in Florida, so I don't think I can get into that.
Okay.
I'm not sure it is, but it may be, and I just want to exercise caution.
So I have some questions along this line. If that's going to be your answer, I understand that. So I'll just...
If you can point to a public filing where this has been discussed, I'm happy to comment on the subject in the public filing, because I think my understanding is it's pretty clear that I'm allowed to discuss public filings, and so if there is a public filing you're aware of, I'm happy to address that to the extent I can recall it.
Okay.
I want to answer your questions as much as I can. I just don't want to run afoul
Right.
of this injunction.
The heart of the question is, you know, he had a skiff at Mar-a-Lago that was decommissioned when he was no longer president, but during the pendency of the case, it would have been relatively easy for him to get that skiff at Mar-a-Lago back up and running. And, you know, he indicates that your office blocked that and, you know, required him to only look at the classified documents, only talk with his attorneys about the content of the classified documents in a DOJ scheme.
So-
And that puts us, you know, a remarkable burden on him, especially given all the other cases that he was defending.
Okay, so if there is a public filing about this, I am happy to discuss this with you. I just want to make sure that there's a public filing, so I'm not running afoul of anything in the injunction.
See if we can get it quickly,
Sure,
if not,
of course.
maybe we'll move on.
Yeah, and then we could come back.
Come back to it. After the immunity determination at the Supreme Court was decided in July of 2024, you filed a remarkably long brief in September of 2024. I think it was like 165 pages, and it, you know, the brief was very, very unusual in terms of length and content. What can you tell us about your decision to proceed with that type of meaty brief? It's almost as if you were writing your, you know, special counsel report in that brief.
Sure. So, as an initial matter, I think the vast amount of the factual material in that brief was not new. It was just put in there to address the issues at hand. The context of this is we received this immunity decision. The immunity decision affected not only the indictment, it affected the evidence we could use at trial. And so for there to be a litigation of this, the defense would have to know the evidence at trial. We would have to say, this is the indictment, and here's the other evidence that we're going to use at trial, in summary at least. We all understood, at least certainly I did, that this case was going to go up to the Supreme Court at least one more time for an interpretation of a lot of the questions that the Supreme Court left open, which we addressed in the final report. Our goal was to have that be one time, and to have the evidence and the indictment get rulings from the court. If the defense didn't like them, they would get to appeal them. That would go up to the Supreme Court. We get a final understanding, and then we'd be back before the court to try the case. And so to do that in one trip, as opposed to multiple trips, and multiple trips could mean years in terms of how long it would take to try a case, that required us to go first, to in essence put this there. And I said this earlier in the day to you, one of the challenges in this case is we had, in my view, a very strong case with a lot of evidence, and trying to condense that into a brief at that stage where we were not going to be precluded from offering things that we thought were important, that could possibly be relevant to any of the immunity issues, but also have a fulsome brief. That's what we filed. It was my judgment that that was what was necessary, and I think, again, if you look at that brief, the vast majority of factual information in that brief had been in the public, or something close to it in the past.
Required you to go first, or you chose to go first? Because the normal case is my understanding, you file a superseding indictment, defense is going to make some motion, they're going to have some reaction to that, and then you would do a brief. But you flipped it.
Well, because in this particular case, we had the opinion that caused us to supersede the indictment. The court said not only what's in the indictment, but the evidence too. And there had never been a point at that point where we had put on the table, here's all the evidence that might be related to immunity. And so we needed to do that. Otherwise, the defense couldn't respond to it. What would have happened would be, we file a brief of our trial evidence, of our indictment. They say no or not. Then that goes all the way up to the Supreme Court. Then we come back from the Supreme Court. Now we're going to do a second year.
Doesn't change the question, Mr. Smith.
I'm sorry.
Was it required, or did you choose it?
I believe that was the most appropriate way to go forward, yes.
It's not my question. Was it required, or did you choose to go that route?
Oh, I chose it.
Okay.
But I'm sorry that I wanted to explain the reasons why I chose it.
And did you have to file a motion with the judge for leave to offer that type of filing?
We had a status conference with the judge shortly after the return of the superseding indictment, and we proposed, my choice, that sequence, but we left it to the judge to decide the timing of that sequence, of when our brief would be due.
And what was the timing of that sequence, to the extent you can recall?
I'm happy to venture a guess, but there's a public record of this. I want to say it was 2 to 3 weeks we were given to write our brief, but trust the record instead of my memory on that.
And so the brief was filed right at the beginning of October, I think, or the end of September?
Whatever the record shows.
And the election was just weeks away, correct?
The election was November 3rd?
Yes.
Yep.
Did you have any communications amongst your staff that this presented potentially a problem with the Justice Department's election year sensitivities guidelines?
So when we got the immunity decision, we had a series of decisions to make. The first was to look at our evidence and see, do we still have a case here? Do we still have admissible evidence that would allow us to proceed to trial? So that's what we did first. Once we determined that we did have that evidence, the next thing we determined is, do we need to supersede the indictment? And because there was evidence before the grand jury that the Supreme Court had clearly said was immune, we determined that we needed to supersede the indictment. And I'm sorry I'm being long, but I think the context will help. Once we determined that, we had to make sure that our conduct in going forward with an indictment and everything after complied with the election year sensitivities policy. And to do that, we consulted with Public Integrity on drafts of the indictment, on our plan forward, and as we set forth in the final report, Ping concurred that we had complied with that policy. And I would just add that policy does not stop prosecutors from trying their cases in court.
Okay. Did you or anyone in your office discuss the potential political or electoral impact of publicly filing that amount of information, just with the election a month out?
My focus was on making sure we complied with the election year sensitivities policy, which is the way the department addresses those issues.
Okay. And so, I mean, the whole purpose behind the policy is not to interfere with elections, right?
Correct.
And so, the way the policy is written, I guess, is that as long as you have filed your case and as long as you're already in court, then there's no limitations on the types of court filings you can make. Is that right?
Well, I will say, and as you know, I was the chief of public integrity. Historically, I don't recall any cases where it ever applied to anything. It was really about investigative stage steps, doing a search warrant or taking investigative steps before an election. But this is one of those issues where this is why you consult with Public Integrity, because they're now the keepers of that policy.
Right. And
so we consulted with them about the path we took, and they agreed that what we ended up doing did comply with the rules.
I mean, after you left Public Integrity, there was a February 2020 memo from Attorney General Barr and Attorney General Garland, in effect re-upped Barr's memo with his own election sensitivities memo. I think he incorporated it by reference, in fact. And this is against the backdrop that a lot of what happened during the 2016 election caused a lot of concern that what happened at FBI, what happened with both the Crossfire Hurricane investigation and the mid-year exam investigation, may have affected the outcome of the 2016 election, correct?
I'm not saying that's wrong. I'm not sure I followed that closely.
Okay. You're aware of the concerns of the Justice Department, in the fallout of the Crossfire Hurricane investigation.
I don't think the election year sensitivities policy was born out of that. I think it's existed for a long time and in kind of the same format for a long time. And I know the last person to sort of restate it was Attorney General Garland, who I think did it shortly before I was appointed, if my recollection is correct.
But he incorporated by reference, Attorney General Barr's memo from 2020. And Attorney General Barr, his memo was in the fallout. It was in the wake of everything that happened with the Steele dossier, what happened with Crossfire Hurricane, and so forth. And so the question is, your 165-page brief a month out from the election, it seems from an outsider's perspective that runs the risk of impacting the outcome of the election.
Yeah, we certainly were not in any way intending to affect the outcome of the election. And to make sure we complied with the policy, we met with Public Integrity to make sure we were doing that. They agreed, and they're the ones who enforced that policy. And so I felt comfortable taking the course that we did going forward.
Did your office ever consider some of the things that happened to President Trump, you know, in the 2016 election with the Steele dossier, with, you know, using the Steele dossier to get, you know, FISA warrants? Did you ever discuss any of that as you know, background that we need to be careful here with President Trump, that we don't, you know, repeat some of the things the Justice Department went afoul of in 2016?
I don't recall ever discussing the Steele dossier or anything like that with my staff. I don't recall that.
And, you know, I know Justice Department officials often like to say that, hey, everyone at the Justice Department is nonpartisan, apolitical, they check their politics at the door. And I think you would say that that is the case with everybody on your team, correct?
I would say that that has been my experience in the Justice Department through both Democratic and Republican administrations. I've worked in the department through both, and that has been my experience.
And, you know, we learned in the fallout of the 2016, the events of the 2016 timeframe, that, you know, there's Peter Strzok and Lisa Page, and, you know, I think we can all agree they were not apolitical and nonpartisan. They were, you know, very clearly, you know, as their text message traffic, you know, bears out, they were, you know, very interested in preventing President Trump from becoming president. Is that something that you were aware of?
I was aware factually of that,
Right.
yes.
And can you agree that, you know, as the text message traffic bears out, those two officials were not, you know, nonpartisan and apolitical?
Well, I certainly agreed with Director Mueller's choice to move them off the team once he discovered those, absolutely.
And did you ever have any discussions with your senior management to make sure that your team wasn't infected by any of those types of issues?
Yes, I did.
Okay. And can you tell us about that?
So I made it clear from the day that I began at the special counsel's office, this was going to be a nonpartisan investigation. This was not, the politics would play no role in it. I think everybody in my office agreed to that. I can tell you of one incident where we were reviewing the email chains of agents who might be witnesses in the case for Jiggly review. And we needed them to give us all their emails. An FBI agent who was working on the case took that direction and actually provided us with his private emails with his family. We didn't ask for that, but he gave us his private emails. In one of those emails, and I can't remember if I saw this or my deputies saw this, he was having a dispute with family members where it was about January 6th. Once I saw that or heard about that, I decided he could no longer work on this investigation. And I think that was consistent with how I ran the office. And I want to also be clear, I never saw that agent do anything that I considered partisan, but just to make 100% clear to my staff, and this is an agent who volunteered this beyond what was required. I want to make very clear that anything like that was not going to be part of our investigation.
The 165-page brief that you filed at the beginning of October, was there any consideration of maybe filing it under seal, at least until the election was over?
Well,
obviously you have to go to the court and all parties would have to agree, but certainly if all parties agreed, the judge would be amenable.
I feel like this came up in the status conference that we had. I can't recall. What I can recall, though, now that you're reminding me, is there was an issue, and this is referenced in our final report, where we filed our brief. They were given time to file their brief. They wanted more time, which would put their brief after the election. We had our exhibits, which were really the evidence, you know, that we were citing. That evidence, they made a motion that evidence, the key facts, should be filed under seal. And before filing their motion, usually the practice is to ask opposing counsel what's your position about this. But they filed their motion before they could get our position, and so we contacted the court, and we said that we had no objection to that evidence being filed under seal if the court agreed. Now, the court ultimately did not agree, and so this is referenced in a footnote in our report. I think that is pretty direct evidence that we were not seeking to put the maximum amount of facts in the public record that we were happy to have that be under seal, and even after the election, if that's what the court agreed.
Okay, but you could have sought permission to file that big brief under seal, right?
I suppose we could have, and again, this is where my memory is escaping me. I feel like this issue was possibly discussed with the court, and I think the record of what, any briefing on this, or what the court said, will be better than my memory about this.
Okay. Did you think it was important that that evidence be in the public realm before the election? So, people could make up their mind about who they were going to vote for?
No, I did not see it as our role to provide evidence for people to make their voting decisions on. Yeah, if I could, just to, the final report on page 107, footnote 258. On the 17th of October, Mr. Trump filed a motion to delay public disclosure of our appendix to the brief, meaning the actual evidence.
say that page again?
Yeah, sure. It's 107. I'll let you get to it. 107, footnote
got it.
258. They filed a motion to delay the appendix, meaning the evidence, until after he filed his own appendix, which would have been November 14th, well after the election.
Yeah.
So that both appendixes will be released simultaneously after the election. He filed that motion before obtaining our position, so we emailed the court's chambers, copying defense, informing the court that we did not object to that procedure, meaning
Okay.
we did not object to our evidence being, in essence, embargoed from the public until after the election. So
Okay.
I think that's pretty strong evidence that we were not trying to have an effect.
Notwithstanding the fact that it's a 165-page brief that you said.
It was.
And that's, in my understanding, that's, first of all, you choose to do it, 165 pages. I think that's 4 times the size of the normal briefs that are supposed to happen with these second motions. And I believe the judge said this was not typical. Is that right?
Yes, but
Judge Chuckin said it was not typical.
she used a word like that, but I would just say, when you say these type of motions, I think filing a brief after an immunity decision is not a common issue, and having to have a new evidentiary issue added to the mix in addition to the immunity issue, I don't think this is.
Is there any new evidence in the 165-page brief?
I'm sure there was, but as I said, my recollection is the majority of the evidence was already public. The brief emphasized how we could prove our case using evidence of his role as a candidate, as opposed to evidence that might otherwise be precluded by the official act. So, for example, a thing in the brief would be that at least 2 of the White House staff members who would have been witnesses, that they also were also working on the campaign. And so, not a particularly important fact in the world, but important for our particular brief. So there were facts like that and others that were new that were in the brief.
I just want to summarize it, but you choose to do this, not required. You go out of the normal order, so that's different. It's 4 times the size of the brief that the court wants you to file, 45 pages, and you do 165 pages. The judge herself said it was atypical. You have introduced new evidence that is public, and you do this 32 days before the election. And public integrity said, just fine.
They agreed that our course was consistent and in compliance with the election year.
Same public
sensitivities policy.
integrity said that all the toll analysis was just fine. Okay. Thanks.
Were you, during the pendency of the investigation, were you aware that at the Capitol on January 6th, FBI had confidential human sources?
I'm sure I probably was. I think there was public reporting on that.
But did you know that also as a part of your work?
I'm sure, yeah.
Okay. And do you know how many there were?
As I sit here now, I can't recall. I know there was an Office of Inspector General report about this, that there were no undercover officers there, as had been reported, but there were informants there, some who had gone on their own.
And did your office oppose President Trump's discovery request for information relating to the confidential human sources?
I would have to look at our filings on that.
Okay. As we understand it, your office did oppose that and said any such information is not relevant to the charged conduct or as a valid defense in the case. And so consequently, you were not in favor of that. Does that ring any refresh your recollection at all?
I'm not disputing what you're saying. I haven't read the filing. What I recall is there was also a database of evidence from January 6th that the DC U.S. Attorney's Office would give access to defendants who were involved in those cases, and we gave President Trump and his attorneys access to that. I'm not sure they ever accessed it, but
Okay.
I do recall that, and there may have been a filing like you talked about.
Okay. Let me get some exhibit. The next exhibit will be number 12, and this is a letter from Stanley Woodward, Stan Brands, about the interactions they had with Jay Bratt on August 24th, 2022, before you were appointed special counsel. You familiar with the allegations that Mr. Woodward raised about Mr. Bratt?
Yes.
I'm going to refer you to two paragraphs in this letter. The first paragraph is the last one on page 1, and the second paragraph on page 2. And please, familiarize yourself with this. But I just wanted to flag in advance that I'm going to zero your attention in on those two paragraphs.
Yes.
Okay. This letter to Judge Boasberg from Brandon Woodward states that again, this is the last paragraph on page 1. Despite the purported purpose of the meeting, it began with Department Attorney Jay Bratt referencing a folder of materials in highlighting Mr. Woodward's professional background. Specifically, Mr. Bratt remarked that he was aware of the fact that Mr. Woodward had been recommended for a presidential nomination to the Superior Court of the District of Columbia. Mr. Bratt also advised that the government's case against Mr. Nuada was strong, referencing his belief that one way or the other, Mr. Nuada would be giving up a lifestyle of private planes and private golf courses, and that it would behoove him, Mr. Nuada, to cooperate in the government's investigation. It was inappropriate for Mr. Bratt to mention the fact that Mr. Woodward had been recommended for a presidential nomination to the Superior Court of the District of Columbia. The only rational inference to be drawn from this reference, combined with the assertion that the government's case against Mr. Nuada was strong, and that Mr. Woodward was not a so-called Trump attorney who would do the right thing, is that somehow Mr. Woodward's potential nomination to the Superior Court would be implicated by Mr. Nuada's decision not to cooperate in the government's investigation. Indeed, to the best of Mr. Woodward's recollection, Mr. Bratt concluded his observations with words to the effect of, "I wouldn't want you to do anything to mess that up," referring to the potential nomination. It is, of course, noteworthy that the statements giving rise to this inference were coming from a senior official with the Justice Department. I asked you whether you had a recollection of these events, and you said you did.
I do.
Do you think it was inappropriate for Mr. Bratt to make a suggestion to Mr. Woodward that he ought to cooperate, and if he does cooperate, if Mr. Nuada chooses to cooperate, that the implication was that his application to be a judge will be looked on more favorably by the Democrats at the Justice Department?
I don't think that happened, but I'm happy to share with you my perspective on
Okay.
this. So,
And let me just say
Yeah.
one thing, if I may.
Sure.
These judges for the District of Columbia, I mean, the Justice Department weighs in on it. Is that not the case? I mean, the White House counsel's office, works to come up with the names they're gonna submit for a nomination. But the way the procedure works is the Justice Department, does the vetting.
I don't think I knew that until this issue came
Okay.
up, which I'm happy
Yeah.
to explain. So, with the District of Columbia particularly.
Okay.
Very short time before this, matter of days, this is right around the time we had given notice that we intended to move forward with an indictment in the classified documents case of both Mr. Trump, President Trump, and Mr. Nuada. As is my practice in cases like this, we gave Mr. Trump's attorneys an opportunity to come in and give me arguments as to why not to indict the case. And in the course of my life, I've heard those arguments and sometimes not move forward on cases. In this particular situation, because my decision would ultimately be reviewed by the Attorney General, who could countermand it, that meeting was with me and Bradley Weisheimer, who was in the Justice Department. Mr. Trump's attorneys were there. It was Jim Trusty, Lindsay Halligan, and there was a third attorney who I can't remember, but I'm sure there's a record of who that was. They gave reasons why they thought the case shouldn't be indicted. And for the first time, this is my recollection, they raised this issue that somehow Jay Bratt had threatened Stanley Woodard. Now, I was surprised by this because we had interacted, I hadn't, but my counsel had interacted with Mr. Woodard numerous times over my time as special counsel. He not only represented Walt Nada, he represented other witnesses on the classified documents case. He represented, I believe, multiple people in the elections case. And so all this time passing, this has never been raised before. I went back to my office. That meeting was at the main Justice Building. I went back to my office, and very shortly afterwards, I informed my deputy, J.P. Cooney, about this and Ray Hulser about this. They contacted Mr. Woodard to ask him about this. I believe there are notes about that, notes of either J.P. Cooney or Ray Hulser. I'm not sure. My recollection of that, and again, they would remember this better, is that Mr. Woodard expressed surprise that anybody had raised this, and he said something to the effect of, well, I know how to make a complaint if I want to. Take that for what you will. That was the initial response.
What day was this?
Yeah,
What time frame, generally?
like early June, so like before the meeting with the attorneys was in the days before we ultimately went forward with the case. I'm not sure how late this letter was after this when I came back to the office. I tasked Mr. Cooney and Mr. Hulser to speak to the people who were present for this meeting. None of them believed that Jay Bratt would threaten Mr. Woodard. It didn't make a lot of sense that a career prosecutor would, in a first meeting with the counsel they never met, threaten them. One of the things they asked about was this issue about the judicial nominating thing. And Mr. Bratt explained that he had not met Mr. Woodard before and not had a case with him, and so he had looked him up. And when you pull up information about Mr. Woodard at the time, there's a page that comes up, and we attached this in one of our motions. It says Stanley Woodard Judicial Nominating Commission. That page makes it look like he is on, at least if you look at it quickly, on the Judicial Nominating Commission, not that he has a candidacy. Mr. Bratt explained to us that he was under the impression that Mr. Woodard was on the commission and raised it as a sort of like icebreaker, like, I understand you're on this commission. Now, whether Mr. Woodard misunderstood that or some other reason, here he says he drew an inference that he was making some sort of threat. That didn't make a lot of sense to me, given all the interactions he'd had with our office. I think Mr. Woodard later started talking about a campaign against him, but he had meetings with people in my office repeatedly in positive ways. And finally, I also thought it was noteworthy that Mr. Woodard didn't bring up this issue for many months. And then the first time that he brings it up in this letter, he's doing it to seek strategic advantage, because he didn't report it to OPR, didn't want it reported to OPR, never asked that. And now he wants it not only reported to OPR, but he actually wants to delay the indictment of the case until that's concluded. I will say that when we confronted, I say we, my deputies spoke to Mr. Bratt about this, he self-reported it to OPR, which is pretty standard in these sort of situations. And so, and I would also just say, this was some time ago, we did a filing on this that I believe is public, and that filing will reflect my best recollection of these things. And so I did not credit these allegations, but we made sure they were referred to OPR.
But you know, a counterpoint to that, if Woodward has a bunch of cases before your office, and he's, you know, representing a bunch of people, I mean, he may have felt threatened, but he also may have felt that it was in his strategic advantage to just try to forget about it, because he doesn't want to make an enemy of Jay Bratt. I mean, isn't that a fair counterpoint?
I don't think so, based on the number of interactions we've had with him, and also the fact that he didn't even bring it up. Someone else brought it up, and when he was, again, I was told when he was confronted with it, he was surprised someone brought it up, made a reference of, I know how to make a complaint if I need to. That was my recollection. And then when he did make the complaint, he didn't just say, I think this should be referred to OPR. He said, and it may be in this letter, that yes, I think that this, let me make sure I get the language correct. Yes. We respectfully suggest that this matter be referred to the Department's Office of Professional Responsibility for a thorough investigation, and that any indictment arising from this investigation not lie until such an assessment is reached, knowing, as we do, that an OPR investigation can take many, many months. So that's my take on what happened, and I think our office responded appropriately to this. I don't credit it, but at the same time, we referred it to OPR so they could look into it.
So if it did happen the way Mr. Woodward or Mr. Brand say it did, you would have an issue with that then? Is that fair?
I have no evidence that any of my prosecutors threatened defense attorneys. If prosecutors under my supervision threatened defense attorneys, they wouldn't be working with me any longer.
Okay. You know, Woodward here is talking about essentially a veiled threat that he believes Bratt was mentioning this off the cuff to try to get him to play ball with NARA's cooperation. So if that had happened, you certainly wouldn't condone that, would you?
I would not condone anyone threatening a defense attorney, but I also say that if you've practiced law and practiced criminal law, I mean, that's just not something that would work. I mean, that's not something that I've seen an experienced prosecutor do, and to do it in front of several other prosecutors. It just, in addition to, for all the reasons I said I didn't credit it, I also think it just doesn't make a lot of sense. But to your point, if, unlike this situation, a lawyer who worked under me threatened a defense attorney, yes, that would be inappropriate.
During the last hour, turning the page to a different topic, you said that you had not yet considered a sentencing recommendation had President Trump been found guilty in either one of the cases. I mean, do you think that you would have recommended? You think you would have recommended a jail sentence, prison sentence, if he was convicted?
I'm not going to speculate on that because that would require a very detailed analysis of the sentencing guidelines factors, of what he was convicted of any mitigating factors. That's not something you do off the cuff, whether someone should be incarcerated or not, or how long. That's not something I would do without significant analysis.
And had your office undertaken any type of analysis on that front?
In terms of a thorough analysis, I don't recall anything like that. I'm sure that we knew how much the sentence could be in each individual thing, but I certainly had not turned to thinking about what sentences should be. As a rule, I don't do that until there's a conviction in a case.
Okay, and but what would have the sentence have been for the charges that you indicted for?
I'm not going to speculate. I mean, if we sat down and went over the sentencing guidelines, we could talk about what that would be, but I have not done that analysis, and I haven't thought or looked at or thought about that issue.
Would that analysis have yielded some jail time, or recommendation for some jail time?
Again, I'm not going to speculate on that because, as I mentioned earlier, you only get to that if you try your case and you prove it beyond a reasonable doubt. We did not do that in this case. There was no trial, and we didn't do that.
Do we have any members here? Just, we have a couple minutes left in our round, so I was just making sure
Sure.
we had some members here that needed to ask some questions. Make sure we factor that in. The individual who worked for Mark Meadows by the name of Cassidy Hutchison was she was a star witness for the January 6th committee proceedings, and she made some real some real outlandish claims that, for example, one of them was that President Trump tried to take control of the wheel of the Suburban that he was being driven in. Is that an allegation that you're familiar with?
The circumstances regarding President Trump getting in the Secret Service vehicle after the Olympic speech, yes, I am.
Okay. And what did your offices, did you evaluate that claim?
We did.
Okay. And what was your determination?
Ms. Hutchinson, regarding that particular claim, was a second or even third-hand witness. She had heard other people talk about that.
Okay.
And so we went to, we interviewed, I think, the people she talked to, and then we also interviewed, my recollection's correct, officers who were there, and including the officer who was in the car.
Right.
And that officer, if my recollection is correct, and I want to make sure I'm right about this, said that President Trump was very angry and wanted to go to the Capitol, but the version of events that he explained was not the same as what Cassidy Hutchinson said she heard from somebody secondhand.
Okay.
That's correct.
On the morning of January 6th, White House officials told President Trump that people at the rally had weapons. This is the President Trump's speech on the ellipse, and that they did not want to go through magnetometers because they didn't want their weapons confiscated. Cassidy Hutchinson initially testified that no one informed President Trump before or during the rally that people did not want to pass through the magnetometers because they didn't want their weapons confiscated. During a subsequent interview, she sort of changed her tune a little bit and claimed that Deputy Chief of Staff for Operations Tony Ornato and other officials did inform President Trump that people standing outside the rally area did not want to go through the magnetometers because they did not want their weapons confiscated. Other witnesses contradicted this claim pretty thoroughly. Did your office evaluate that claim?
Yes, and I think I discussed this earlier. We interviewed a number of people, and I think on this particular claim, there were a number of different perspectives about that. I believe it was Ms. Hutchinson, Mr. Ornato, I believe Mr. Meadows we spoke to about this. As I sit here right now, I cannot recall what each of them said. I know each of them were seeing it from a different perspective, and they were with Mr. Trump at slightly different times. So as I sit here now, I can't recall, but I do recall that there were different perspectives on that question, yes.
Did your office consider whether you would call Cassidy Hutchinson as a witness at trial?
We didn't make a final determination about any witnesses, but my recollection as I sit here now is that one of the issues, there were two issues really. One, there were so many witnesses that we could have called, and there was a need if we wanted to present a case in a digestible format where there wasn't just weeks and weeks and weeks of testimony, we had to slim it down. And my recollection with Ms. Hutchinson that at least one of the issues was a number of the things that she gave evidence on were secondhand hearsay, were things that she'd heard from other people, and as a result, that testimony may or may not be admissible, and it certainly wouldn't be as powerful as firsthand testimony. So I don't recall if we made a final determination about that, but I remember in my mind that being a consideration that some of the things that she could offer testimony on would be hearsay, and we wanted to condense the case as much as possible for a clear presentation.
Did you reach a determination about whether her testimony was reliable?
I don't recall reaching any sort of conclusion like that because we were, again, far away from trial. We hadn't made final determinations.
If you were a defense attorney and you were given the assignment of cross-examining Ms. Hutchinson, would you consider that assignment a very challenging one?
Well, if I were a defense attorney and Ms. Hutchinson were a witness, the first thing I would do is seek to preclude some of her testimony because it was hearsay. And I don't have the full range of her testimony in front of me right now, but I do remember that was a decent part of it, and so that would have been my first gambit if I was a defense attorney.
There was other evidence where she said she wrote a note, whether it was to Mr. Meadows or Mr. Trump,
Yep.
But it wasn't her handwriting. Eric Hirschman wrote the note.
Yes, there was a conflict between them on that issue, that's correct.
you know, a witness says, I wrote a note, that's my handwriting. I mean, that's a pretty serious, potentially false statement, correct?
Well, like I said, we didn't make any final determinations about who we were going to call or not, but there were instances, you cited a couple where we had evidence, we had different perspectives about an issue, we had secondhand hearsay about an issue, or two witnesses not remembering something the same way. So those are all accurate.
Was your office, you know, let me restate and just say that numerous witnesses that were ensnared by the investigation complained that they were debanked. Does the term debank mean something to you?
No.
Where they were basically told by their bank that they needed to go find a different bank. And there's a long list of, you know, Trump allied, you know, officials that were subpoenaed for the grand jury, that were, you know, brought into your investigation, that claim they had been debanked, and that Capital One told them to go find a different bank, and numerous other banks. Do you know anything about that?
No, I do not.
Okay. So your office didn't have any communications with banks urging a bank to separate from any other customers?
I have no knowledge of that.
Are you aware of that allegation, or is this the first you're hearing of it?
I'm trying to think. I didn't know what the term meant when you first said it, so, I mean, in the scheme of the world, have I heard of the word debanking? Maybe, but if you'd asked me to define it when you first said it, I don't think I could have.
Okay. But have you, so you haven't heard that allegation that some of the folks in President Trump's inner circle have complained that they, you know, were kicked out of their bank?
Complain to the special counsel's office?
No, they've complained publicly that you know, the fallout